Hey all, welcome back to the Law Read Slowly. So in the last session, we had started introducing section 9 of CPC, which is a gateway into the CPC. We had discussed why is that phrase used so often for this particular section, because CPC only comes into your life when you are embroiled in a court case. How do you get caught up in a court case? Is when you file a court case or a court case is filed against you. And what does Section 9 do? Section 9 gives individuals the inherent right to file a case by giving every civil court an inherent right to try a case. So, Section 9 says that every court should have the power to try every suit of civil nature. So, flip side of that, an inference of that would be what? That every individual has a right to file a suit of civil nature in a civil court. That is how the inherent right to file a civil suit arises. So when you file a civil suit, that is when you are in middle of a civil suit, and that is when you start to care about the provisions of the Code of Civil Procedure, because these are the provisions that are going to ensure that you get justice either as a plaintiff or even as a defendant. Because if you don't follow the law, if you operate the suit on whims and fancies of any of the actors involved in the civil suit, it is going to result in injustice. So following the law is the primary goal, why we have procedural law written down in the first place, so that it gets followed and hence justice is served to everybody who is involved in the case. Right? Now let's read section 9 before we proceed. We have read it in the last session as an introductory reading for this section, but today we are officially properly beginning with section 9. How did we get to the discussion on section 9? We began with jurisdiction. So this is all within the topic of jurisdiction. If you see, we began with jurisdiction. We discussed the meaning of jurisdiction. We discussed different types of jurisdictions. We discussed the meaning of the word competency. We compared the word competency with the word jurisdiction. We saw the difference between the two, and we saw how the ambit of competency is smaller than jurisdiction. Then, from the three kinds of jurisdiction that we had studied, now we are focusing upon subject matter jurisdiction. We also have pecuniary jurisdiction spoken about in the CPC. We also have territorial jurisdiction spoken about at length in the CPC. We are beginning with subject matter jurisdiction, and section 9 is also a very, very, very important section for any kinds of exams that you're writing, be it your law school exams, be it any form of competitive exams, be it any kind of judiciary exam. Section 9 is very important. You can get a direct theory question, you can get a direct application based question, because section 9 has so much scope. So section 9 is your gateway into CPC. As a lawyer, as an advocate, lawyer and advocate, you must know they're two different terms. As a lawyer, as an advocate, as a law student, as a judicial aspirant, as a young professional in a corporate law firm, you might be in the litigation division of a particular firm. It will come very handy for you. So let's read section 9 and then we will proceed from there. Open your barracks, please. Section 9 is present where? Part 1, which is titled as Suits in General. And then there's a subheading, Jurisdiction of the Courts and Res Judicata. Let's read section 9. Courts to try all civil suits unless barred. This marginal note, this heading of section 9 itself is clarifying what is the core principle with respect to subject matter. The subject matter that every court, every civil court is competent to try is what? That the suit should be of civil nature. If the suit is of civil nature, automatically you should know that a civil court can try it. Unless barred. Unless there is something in the law which is stopping a civil court from trying a particular suit. If there's nothing stopping the court is automatically presumed to have the jurisdiction, presumed to have the competency to try a suit of civil nature. That is what is the very important import of this particular provision that you have to gather. It's not the other way around. You don't say that you have to show why this court can try this suit. The burden of proof is on the person challenging. It's the defendant. So if the plaintiff has filed a suit in court A, then it will not be the plaintiff who will be asked to prove that you prove why does court A have jurisdiction to try your suit. Defendant will come into the picture and say that, my lords, court A does not have jurisdiction to try this suit. And it will be the defendant then. The issue that will be framed, the preliminary issue that will be framed by the court will be whether court A has jurisdiction to try this suit, question mark. And then court will put a hyphen and write onus of proof on defendant. So it's the defendant who will have to prove that this court does not have the jurisdiction. Why? Because section 9 says that if nothing is given in the law, be it CPC, be it any other law, if nothing is barring the jurisdiction of a civil court is free to try a particular suit of civil nature, provided your suit is of civil nature. If it's a friendly agreement, no. If it's a suit of civil nature, then any civil court can try it. Clear? It's a very important point, because in civil suits, this issue of jurisdiction is raised at the very outset. We have drafted plain, we have drafted a written statement, we have always raised the issue challenging the jurisdiction of the court in our written statements. We've also seen how it gets dealt with. We've discussed in Order 14, Rule 2, that usually the general rule is that a court must decide all the issues it has framed, and it should not stop at only deciding preliminary issues, except when such preliminary issue concerns jurisdiction. So that is making the court itself incompetent to hear the suit. So there's no point making this court hear the suit and then at the end saying in the decree that we don't have jurisdiction. So while we have discussed all the issues, there's no point in us discussing the issues, because anyways our judgment is not binding. The jurisdiction becomes one such issue which can be decided, and only the decision of jurisdiction itself is enough to stop the suit in that court. Now, who will raise this issue of jurisdiction? Defendant comes. What is an issue? We have discussed at length. An issue gets framed when both parties disagree on something. Plaintiff is saying one thing, defendant is saying one thing. So that point becomes an issue. So if plaintiff is saying court has jurisdiction, defendant is saying court does not have jurisdiction, the court will frame an issue on jurisdiction. And Order 14, Rule 2 tells you that court has the liberty to decide the issue of jurisdiction first and keep all the other issues related to facts and merits of the case for later. And if jurisdiction is said to not have been there, then what will the court do? Court will return the plaint. We've discussed Order 7, Rule 10. We've spent 2 whole sessions on it. We've also written on it. You see how everything is connected. If I would have not taught you return of plaint and I would just teach you Order 14, Rule 2, then you will think. At that moment, you might feel very confident that yes, preliminary issue will get framed, jurisdiction will get decided. If there's no jurisdiction, the case will not proceed. Case will not proceed. What is that phrase? What will happen if the case is not proceeding? Nobody is going anywhere. The case is not proceeding. You should know it means that the plaint will get returned back to the plaintiff for not having jurisdiction, because it is a plaint which this court shall not try. So the court will return the plaint. We have discussed plaint can be returned at any stage of the suit. Even in appeal and revision, it can be returned. Clear? Now let's come to section 9. Section 9 says, the courts shall, subject to the provisions herein contained, have jurisdiction to try all suits of civil nature, excepting suits of which their cognizance is either expressly or impliedly barred. We'll read the explanations later, they're very easy. Let's first deal with the main paragraph. Now, if you see on your screen, let me show you. So yeah, if you see here the breakup of section 9, what does it say? First, if you remove certain parts of section 9 and just read the first part, that is saying, the courts shall have jurisdiction to try all suits of civil nature. If you read just that much part and you don't read the latter part and you remove the bracketed part from between, that is what it will say. That is what the section will say. What will it say? The courts shall have jurisdiction to try all suits of civil nature. What would that mean? That every court in the country, every civil court in the country can hear every suit of civil nature from anywhere in the country. So any case arising in one territorial jurisdiction in Punjab, for example, can be heard by a court in Tamil Nadu. A case arising in West Bengal can be heard by a court in Madhya Pradesh. But we have discussed at length what would be the huge issue with that. It would mean there is no order, there is no system. Some courts are being clogged with case laws because everybody wants to get their case tried in that particular court in the country. Whereas the court nearest to people where the issue is arising is sitting idle because people don't feel like going to their local courts. They are like, we'll go to a court which is in Goa, we'll go to a court which is in Ahmedabad, we'll go to a court which is in Amritsar, but we'll not go to a court which is in Calcutta, even though a case has arisen in Calcutta. The territorial jurisdiction is Calcutta. Why? Because if Section 9 would have said, the court shall have jurisdiction to try all suits of civil nature, that's all. But no, that is not what Section 9 says. Section 9 has inbuilt exceptions to this broad, this plenary rule. So it's not allowing every court to hear every suit of civil nature from anywhere in the country of whatever value. It is putting certain restrictions on it so that we adhere to what? The issues related to jurisdiction, so that not everybody is ending up anywhere. That is why the first exception that the law, that the code itself puts on this general power is what? It's on your screen. Subject to the provisions herein contained. Where are these provisions? What is herein? Herein means rules of interpretation. Herein means the provisions contained in the Code of Civil Procedure 1908. If these provisions are barring what? The power of a court to hear a civil suit, then that bar put by a provision of CPC will operate. And you cannot say that because Section 9 is so big, so any bar that is being put by CPC also will get discarded and my case should get tried. No. A bar that is imposed by CPC itself will overrule, will supersede the power laid down in Section 9. So tomorrow, if you file a case in the wrong territorial jurisdiction, the land which, with respect to which the case is concerned, is lying in Bathinda, and you're filing the suit in Amritsar, then Amritsar court can say that no, you cannot file a case in Amritsar because CPC says, if you read sections 15 to 25 that deal with territorial jurisdiction, there it is clearly said that you have to file the case in the territorial jurisdiction. So territorial jurisdiction is a concept, is a bar provided in CPC which is stopping the Amritsar court from hearing a suit which is in Bathinda.